Hello, my name is Cletus and welcome to the clan. So without further ado, let's get into this video. But before we get into the video, you guys already know what to do. We need to smash the like button so that the algorithm is triggered. As you guys can see, the algorithm is getting triggered. As you see, the numbers are growing. And I want to say welcome to everybody that is new on this family called the clan. And you are officially a member of the clan. Honorable member of the clan. Thank you so much for considering us. And if you're watching my videos outside of the clan, please consider subscribing so that you too can become an honorable member of the clan. So let's get into the video and go to the Gauteng High Court at the Mngomezulu murder trial. As you guys already know, today came to a full wrap of testimonies by Ntanzi, and the defense closed their case. But before we get into that, I have an announcement to make. There are going to be 2 weeks dead space that we need to occupy. Please go to my community tab. I put up a poll there for you to vote on what to do during these 2 weeks. Other than that, I'm going to be reading from my script once again because I need to head off. I'm going somewhere. It's not a dinner date this time, but it's something else, sort of like a dinner. Anyways, it's none of your business, clan. We'll talk about it later. Anyways, let's get to the script. What I have written on what transpired in the Mngomezulu murder trial within a trial. So the defense closed its case after Ramusipili asked Ntanzi a couple of questions in respect of Njiako opening a case against Njiako, and how Ntanzi did not pursue the opening of a case against Njiako, but still wishes to open the case against this particular lawyer. So those are the things that Mr. Ramusipili asked Ntanzi about. And Ntanzi once again told the court that he knows nothing about this man. He still wants to know who is he, who paid him, who called him, and all of that stuff that he's been saying during cross-examination with the state, as well as in his evidence in chief. So the question is, where to from now for both the defense and the state, since they have closed their cases? So these are just my observations, guys. They are my opinions as well and views of the things that I'm going to be saying in this video. But first, let's get into the little bits of what transpired at the Gauteng High Court. It was arranged that the state will prepare and file its heads of argument between today and next week, Friday. Even though Advocate Baloyi tried to be slick when he told the court that the state and the defense were to file their heads of arguments at the same time. To Judge Rata's surprise, who reminded the state that this is its case, and therefore they are the ones who should file first and then discover their heads of arguments to the defense, so that the defense can answer to the state's heads after a certain period of time that the state will determine as per the law permits. Advocate Mshololo stood up and agreed with Judge Rata, assisting Advocate Baloyi, that according to the procedure, the state ought to prepare and discover and file its heads of arguments to the defense so that defense can answer to the state's heads of argument within 5 days. Baloyi's excuse was the reason why he had suggested that both the state and the defense file at the same time is because he was avoiding wasting time. What was Sibanda doing? Anyways, let's not go there. As it will be 2 to 3 weeks to do this process if the state had to file first and then discover, then the defense has to answer to the heads of argument, preparing their own heads of argument, and then file, and then about 2 or 3 weeks later, then they come back for the oral arguments. It was then agreed that the state will file first, discover its heads of argument to the defense, and by the 1st of March, the defense ought to have filed their heads of argument. And then Advocate Baloyi suggested the 4th of March 2024, which is going to be the day where oral arguments are going to be submitted to Judge Rata. Judge Rata then indicated that Judge President is not going to be happy with the length of time that this is going to be done. He he was hoping that this will be done within 2 days. The state prepared and filed its heads of argument today and defense tomorrow and return on Monday and hear the arguments. So basically, Rata was saying that Judge President was hoping that the moment that the defense closes its case, immediately they're going to start preparing and filing their heads of arguments during this weekend. And then on Monday, they come and argue their heads of arguments, which is something that Advocate Baloyi was trying to say, but Rata reminded him that, by the way, according to the process, you are the state, this is your case, you're the one who needs to first prepare and file your heads of arguments, discover them to the defense. And then Baloyi was like, this is going to take 2 to 3 weeks. And then now Judge Rata comes back and say, Judge President is not going to be happy with this time that is going to be wasted this coming 2 weeks. I was like, okay, cool. Anyways, you're doing that to Baloyi, not the defense. I don't care. So if you were wondering, what are heads of argument? Because I've been getting that question a lot. Clancis, what is heads of argument? What is heads of argument? Now here is what I looked up and found. I'm just going to make it as simple as possible. These are basically persuasion points to try convince the court that their case was most persuasive for the court to reach a decision. So you're going to have the state that is going to tell the court, according to everything that they canvassed out of the witnesses that they've had on the stand, including the accused person. And then all these pointers, they are going to argue them to try and convince the court that they are likely or highly likely have a case for the accused to answer. And then the defense themselves will respond to the state's heads of argument. That is why the state have to prepare the heads of arguments, their own, and then from there submit it, this is called discovery, to the defense and say, okay, this is what we are going to tell the court. And then the defense looks at the state's persuasive points, and then they will rebut that by preparing their own heads of argument and try and convince the court why these confessions should not be admitted into evidence. The state wants to persuade this court to come to a conclusion that these confessions were legal and it reached all the requirements that needs to be adhered to in order for the confession to be admitted, while the defense is going to be saying the opposite. So I'm sure you have heard many a times during cross-examinations, whether it was for the state or for the defense, where if the witness does not answer the question, or maybe there's several objections on around a certain point, then either the state or the defense will say, we will leave this for argument. Basically, this is exactly what they mean, that they are going to argue this point in their heads of argument, since during cross-examination, they did not get the satisfaction to get that question answered. I hope I was simple. Oh yeah, I'm also speaking to the 30%ers that are hanging out in the wings. Yeah, y'all sitting right there at the back. Are you okay? Cool, great. So I'm just going to read what I just said. Remember when the state and defense kept saying, I will leave this for arguments? They meant instead of wasting time during cross-examination, I'll leave this point or evidence for argument. This is exactly what they mean, heads of argument. Just like the issue of occurrence books that Advocate Mngomezulu tried to table once Mr. Ramusipili had closed his case. I want to touch on these occurrence books because the defense really ticked me off on this one. I remember very well on several occasions when Gininda was on the stand, I said the defense will have to verify these OBs and make sure that they are, as Gininda says, that it is the police station and these police stations that Ntanzi slept at who made those entries that he was brought with no injuries. I even said, call the police officers if they are named to the stand and confirm whether these are their handwritings, number one, that they are the ones who made those entries, and also compare those handwritings with the signatures to ensure that indeed they were not written by Sergeant Mukhanu. By virtue of the defense not objecting or making the above mentioned application, they actually agreed to the legitimacy of those occurrence books as facts. It was quite upsetting seeing Advocate Mngomezulu now try to correct the mistake of not objecting. Ntanzi was put through hell by Sibanda about those OBs, and Advocate Mngomezulu still did not say anything to rescue Ntanzi by asking the court to have the officers that wrote those entries to take the stand. At one point during Ntanzi's testimony, it was Judge Rata who asked who were the police officers that made those entries. He was asking Sibanda. And then Sibanda, I remember he said he will look into the original OBs, and after long adjournment, he is going to tell the court who those police officers were. 2 names were given to court after long adjournment because Sibanda asked the court if he could go look at the original OBs. The defense should have gotten up and asked for those 2 officers to come to court and confirm that it was them who made those entries. I just didn't understand why they did not do that. Judge Rata then challenged Advocate Mngomezulu to bring him an authority that forces him to do what Advocate Mngomezulu is asking for after the cases have been closed. And I thought Judge Rata actually made a point. I didn't know of this, but it made complete point that both the state as well as the defense close their case, and then you come after these cases have been closed and you want to make a submission. I was like, okay, I understand what Judge Rata is saying. Judge Rata even opened the authorities from England, Canada, and Australia. If you know your history, you would know why he made that suggestion. Because they were also colonized by the English. And the English brought in their English law. Just like South Africa once upon a time was an English law, common law country. Same goes with England, Canada, and Australia. I'm not quite sure which other country as well. So he was saying if he can find an authority that forces him from any of these countries apart from South Africa, then he will rule that what Advocate Mngomezulu was submitting, he would also admit and then have these occurrence books considered as non-factual. Judge Rata said, I am willing to be persuaded by them when submitted on Monday. Advocate Mngomezulu knew that those authorities do not exist as much as Rata knew that they do not exist. However, Judge Rata did give Advocate Mngomezulu an alternative which is provided for by the law to reopen the defense case. If this is what the defense chooses to do, then all the witnesses that have been called in the trial within a trial will be recalled and cross-examined on the OBs. Of course, I favor that they reopen the cases. However, they must reopen them on the basis or on the grounds of the occurrence books, so that the court can call the police officers of all the police stations where these OB books were brought in by the state that made those entries and confirm that it was them, and with their handwritings confirmed to be that of theirs, not Sergeant Muganu. Rightfully so, the judge turned to Advocate Mngomezulu and asked him if that's how he also felt, considering the fact that Ntanzi is his client. So Advocate Mngomezulu, whom I thought he was a little bit reluctant, responded to the judge and said he personally feels that he will take the matter of OB books into arguments. This then prompted Advocate Mngomezulu to abandon his argument, and that was the end of that submission by Advocate Mngomezulu. Again, I found myself quite upset at Advocate Mngomezulu finally waking up to the factor that could weaken the defense's strong case. After I calmed down, I realized that the defense case is still strong irrespective of whether the OB books were not objected to. The fact is, the state failed to disprove all of Ntanzi and Sibiya's assertions about their experiences with the police, trying to smear the death of Senzo Meyiwa on them. It's going to be interesting to hear the state's argument to why the court should admit the alleged confessions into evidence. In as much as we don't trust Judge Rata, this is now my view. Inasmuch as we don't trust Judge Rata, I doubt that in his 20 years on the bench, he is unaware of police brutality. He's not aware of underhand tactics police use, like Gininda, probably even remembering how the special force of the apartheid police worked in order to abstract a confession out of the victims. He probably remembered John Foster Square, where Steve Biko was tortured in a similar way as Bongani Ntanzi. Unfortunately, Steve Biko, who was resolute and would not give in any of his comrades to the apartheid police, they tortured him to death. What Ntanzi testified was nothing short of apartheid police tactics. And we must also not forget that Sergeant Muganu, who took to the stand when he made his testimony, he said that he was a police officer since the 1980s. He is an apartheid police. And he certainly learned from the best. And he brought those tactics into democratic South Africa, where humans are bestowed with constitutional rights, including people that are suspected of heinous crimes. But then again, heads of argument will give us a clearer picture as to where this is going. I am hoping that when Judge Rata dismisses those so-called confessions, the judge also throws out the main trial, as the state had failed to prove that the 5 men stand accused of killing Senzo Meyiwa are the correct accused. The confessions were riddled with constitutional errors. They were not taken down properly. Even the magistrate that purported to take the confession of Ntanzi illegally recorded him. And don't get me started with the dentist, who is also a GP, a cardiologist, a physician, and all the fields of medicine all in one on Ntanzi. Suppose the confessions are admitted by the court. What happens? From what I understand, the main trial continues and those confessions will then reveal the content of what is inside. And this includes the names of all that were involved, how they were involved, and for what purposes that Senzo Meyiwa had to die. If you remember, in Gininda's testimony, he dropped a bombshell in the name of Kelly Khumalo, hiring Izinkabi to kill Senzo Meyiwa. So if the confessions made mention of this, then I think, or it is possible that Kelly Khumalo will be placed under arrest. I am not sure if she will be prosecuted separately or she will join the 5 accused as accused number 6. However, if the court does not admit these so-called confessions into evidence, then we will never know what was in the confessions. And I hope for an acquittal of all the 5 men. Accused number 1 goes on and starts serving his sentences for the drug and ammunition conviction he received on the 12th of December 2023. I think it was 5 years each and to be served concurrently. If I'm not mistaken, I stand corrected on this one. I think after getting acquitted, Moses Sibiya should appeal that conviction or those convictions. Bongani Ntanzi will go back to what he used to know to be his life, hopefully gets his job back and continue to take care of his kids and family. Accused number 3, accused number 4, and accused number 5 will continue to serve their life sentences as per the crimes that they were actually convicted for. South Africans will lick their wounds and continue to have the Meyiwas in their hearts and hope that one day one of the people that were with Senzo Meyiwa on the 26th of October 2014 will develop a conscience and confess. Hopefully that confession, due diligence will be followed by the inept police so that we can get justice for Senzo Meyiwa. As for Gininda, Sergeant Muganu, Sergeant Mukhola, Mabena, hi Mabena, Jonathan, Cronje, Mutlapeng, the dentist, his assistant, Mjiako, the whole lot of them, karma will deal with them in the harshest way possible. And I also hope that the ills that we heard in this trial about our police force, of how they conduct their business as police officers on citizens and civilians, it cannot be that taxpayers are paying for their taxes so that one day they find themselves accused of a crime they did not commit and get beaten, tortured, electrocuted, tubed, and all of those things, because not everybody is as strong as Ndanzi and Sibiya. Many people come with different ailments and health conditions. Somebody could die in the hands of the police. I further say, this cold case unit to be reviewed and investigated and investigate all convictions that came out of this unit if they were conducted as per the Constitution. In closing, I think that the people that may be serving sentences of crimes they did not commit as a result of the cold case unit, they must approach the Supreme Court of Appeal. Like I said, there's something fundamentally wrong with the conduct of this cold case unit, and it must be investigated, including its head. As for Mr. Mngomezulu, he has a lot to answer, and I hope whatever happens to Bongani Ntanzi, he continues to open a case against Mr. Mngomezulu for fraud, corruption, and misrepresentation cases against him. Mngomezulu played a major role in the torment of Bongani Ntanzi, unleashing him to the wolves. Basically, those are my thoughts, my views, and my opinions. So the court is postponed until the 4th of March 2024 for heads of arguments. So like I said, guys, I did put up a poll sort of for you to vote what to do in the next 2 weeks building up to the 4th of March 2024, because the last time in December when the court closed, my analytics dropped so drastically. Right now, I'm still trying to recover. The algorithm almost forgotten about me. Now, you guys are helping me so much by liking the videos, and the algorithm is now remembering me. That is why it is now promoting my videos. So I do not want to find myself in the same similar situation as I found myself in December into January. So that is why we need to occupy this dead space for the next 2 weeks. I did put up 3 suggestions. There is a current case of a 21-year-old alleged serial killer by the name of Fiso Mkhwanazi. That trial is going really, really quick because he's already on the stand testifying on his behalf. Last week, his father, or is it last week or the week before, his father, whom a trial within a trial admitted his confession into evidence, testified against his own son. So that trial is moving really, really quickly, and I'm thinking to bring it to the clan, its last legs, I think, of that trial for the next 2 weeks until the Senzo Mewa case comes on. And if the Mkhwanazi case continues even after Senzo Mewa's trial is over, then we'll continue with that one. However, the Thabo Bester one, because I saw some people suggesting that I bring the Thabo Bester here. Unfortunately, you guys do not watch the Thabo Bester case, so I moved it to my true crime YouTube channel called The Iron Bars. That is where that trial I'm going to follow it, not on here for the clan. If you are interested in that trial, then you're going to have to go to my true crime YouTube channel. I hope I was clear on that one. If you like the video, give it a like. If you didn't like the video, give it a like. Anyways, do subscribe to my YouTube channel. And don't forget to click the bell notification so that you get notified every time I upload a new video and I'm sweating bullets. Thank you so much to everybody that's super thanking my channel and supporting it financially. You guys, I appreciate you so very much. And don't forget to leave me a comment down below and let me know what did you think about the wrap-up of the trial within a trial. Whew. Thank you for delivering us from Sibanda. It's all I am so grateful for. And also share this video far and wide. I'll see you next time with a new video. Goodbye.